facilitate a common understanding and a common agenda for what the problems are, and then what some of the solutions may be, and what can be specifically demanded through a PIL or through a petition to the Human Rights Commission or a Women's Commission or some other administrative body. And aside from the treaties, I would urge everyone to look at, and this information is very easily available over the internet and in publications by the Centre and other groups as well. What the general comments and general recommendations issued by UN treaty monitoring bodies on the right to health. Others under CEDAW, under the Economic, Social, Cultural Rights Covenant, what treaty monitoring bodies have specifically said to the government of India that they need to do. For example, the Committee on the Elimination of Racial Discrimination has specifically expressed concern about the marginalization of, tribal women and other disadvantaged women from access to healthcare. I mean, that can be used to put pressure on the government of India through litigation, through other types of advocacy, by lawyers and non-lawyers to say, look, you have a duty to act, and to help, promote, push for solutions. Likewise, the Special Rapporteur on the Right to Health Qualified report, which has come up a few times, that's out now. So that, the supplementary note, we can all go through that and then really pinpoint and prioritize what we think the government of India needs to get an answer for. So that's another very useful tool that has become available. I think in terms of other issues now, moving away from maternal mortality a bit, but there are other related issues, and I would urge Human Rights Law Network to consider broadening its docket a bit. There are all these cases on maternal mortality now which have to be continued. And I think this is a challenge. There's so much that needs to be done, and it's really, kind of one group that is the forefront of this. But, recognizing that, this is a lot of work, I would urge HRLN to really start thinking about the issue of unsafe abortion. Colin and others have raised this question several times, so I see that there is already interest. But, forced pregnancy does violate women's human rights. There's a lot of, there are international standards, there's a lot of comparative jurisprudence out there that can be used to really make this argument here, because we see this problem of forced pregnancy here. I think it's an issue of framing. And then, the issue of legal rights and how we've seen that pop up in recent decisions and the kind of language. I think that is something that we all need to pay attention to, and HRLN is in a very good position to, since these have come up through judicial decisions, I think it has to be led by a legal group like HRN. So cases to really sort of pay attention to this whole issue of legal rights and how they're framed, and the fact that legal rights are not absolute, they cannot be absolute, there's no legal support for that anywhere. The opposition might say that there is, but their ideas really come from religious doctrine, and the state has an obligation not to mix the two. So, there's a lot of support in international law, and I think, these are issues, the trends that we need to be very wary about. Again, going back to the range of legal strategies, I think if we really want to litigate on unsafe abortion, looking at the quality of care, the poor quality of care of government hospitals, I think, it can really lead us to very concrete issues that can be litigated, because that is a huge problem. And then there are cases of outright denial that keep popping up as well. Even the Gujarat case where the doctor told the rape victim to go and get a court order, it's absolutely ridiculous. It makes you think, maybe that doctor should be penalized in some way for forcing that girl to go through all that trauma. There is definitely, the mental trauma that she was forced to go through and to run back and forth between the court, different courts. There has to be some accountability for that as well. And I'm sure there are lots of other cases too that come up like that. So issues of denial, and then really looking at specific groups. And I would say adolescents are particularly vulnerable. And under international law, the government has a heightened responsibility to ensure the rights of adolescents. So, within the realm of unsafe abortion, I think quality of care, cases of denial, and then looking at specific groups can be very strategic. I think we have to find different entry points. And then legal background, of course. Whether the third case is a good idea or not, I think it's too soon to make that judgment. The bottom line is that a 20-week cutoff is somewhat arbitrary, and it is criminalized behavior that should not be criminalized in the first place. So, there are very, I think, obvious legal barriers, and there are laws and policies that maybe that might have provisions that are discriminatory discriminatory on their face. I think, because there are different types of litigation, right? You have the individual cases, and then you have broader PILs where many individuals are affected. And then you have the laws and policies that have loopholes or problematic provisions that you might want to challenge. For example, NRHM has that condition, right, where, benefits are provided only up to a certain number of pregnancies and not beyond. And exceptions are made for a third pregnancy if the woman consents to be sterilized. And so, there are provisions like that maybe we need to consider challenging. We'll have to find evidence of harm, but, that's another sort of strategy, I think, for litigating and for addressing concerns relating to maternal health and access to services. And then the other related issue that I would urge HRLN to consider is also looking at family planning, access to family planning, because all these issues are interrelated. One is usually the cause for another, or access to one can prevent another issue. So there's a trend, especially now in Eastern Europe, we have started litigating for contraceptive subsidies. And in a country like India, where unaffordability seems to be the biggest barrier, aside from lack of information and counseling, I think it could be interesting to think about that. And I know there's a certain history and a dark history around contraception, which has led to many concerns and fears, but I think the time has come to sort of maybe detach that a little bit and look at the presence. I mean, after all, which drug doesn't have potential side effects? And I say this as a woman, myself. A lot of us here are using contraception. We use it knowing the side effects, but we take risks. There's certain contraceptives. I use a contraceptive that could potentially cause a blood clot. There are all these things that I think the point is that women have to have access to a range, have access to information. They have to be able to make an informed choice. But I think the issue of side effects should not deter us activists. It can be, obviously health groups are a very important source of information about violations and problems within the health system. But I think it can be useful for HRLN to start looking for also sort of engaging with groups that work, for example, on violence against women and other issues where violations of reproductive rights also occur. For example, this girl was a victim of rape. If she had had access to emergency contraceptives, maybe she wouldn't have ended up committing suicide. Or if she had had enough information and support and then was able to get the abortion safely, she would not have committed suicide. So my point is, there are areas outside the health area where reproductive rights violations are occurring. So it can be, I think it's important for HRLN to sort of start looking in these other areas, because there are issues where, many issues come together. The adolescents, denial of access to health care, and it's a criminal act as well, the sexual violence aspect too. So it can be very strategic to work, I think, identify cases where there are multiple issues that come together, because, that can also, if you get a positive decision in a case like that, it can also really, it can have an impact, a broader impact. So I would urge HRLN to look outside the health system also. I've already been given a chit. I think my time is more or less over. I think just broadly looking, as the process of identifying cases for litigation is not easy, obviously, which is why HRLN organizes these meetings every year, and I commend HRLN for really reaching out to groups more broadly to try and get ideas. But I think just to give some of the non-legal groups here some ideas for, what kind of information needs to be passed on to HRLN, which they can then analyze and assess whether it's possible to bring cases. Is to really look at the issues of affordability or unaffordability, issues relating to